arrived here in just the last couple minutes. It is 9:00 a.m., so we should be ready to go. My understanding is that we have Commissioner Holzman and Commissioner Coleman and Chairman Sylvie with us. So from what I can tell, we have all the essential parties present. So let's get on the record this morning to resume the evidentiary hearing in case number EU-2020-0350. This is Evergy's application for an accounting authority order related to COVID-19 expenses. Okay, so the time is now 9:01 a.m. This is the second day of the evidentiary hearing. And I think we heard from Mr. Robertson before we actually got on the record yesterday, but it was actually Ms. Henry who appeared for Sierra Club. So, Mr. Robertson, did you want to enter your appearance this morning?
Yes, Judge. I will be replacing Ms. Henry as attorney for the Sierra Club today. My contact information is on the filings in the case.
Okay, thank you very much. And are you familiar with how to mute and unmute your line there on the screen? Do you see that?
Yes.
Okay, your line seems okay right now, but I want to make sure everyone understands that their line should be muted unless they're addressing the commission. That will help us have a better quality proceeding for Ms. Bench, our court reporter, to get the record today. So I don't know that it's necessary for all of the entries of appearance to be repeated, but I would like to know who's present for Evergy as far as counsel goes in Kansas City, because I can't see everyone.
Judge Carl Zobrist speaking here, and Robert Hack.
Thank you very much. And then we also have Mr. Fisher, who I can see. So those are all the preliminaries I thought we needed to get into before we went on to testimony this morning. But if anyone has anything they wanted to raise before we move on to Office of Public Counsel's witnesses, please speak up now so that we can take care of that. Did anybody have anything? Okay, it doesn't look like it. So that means that if Office of Public Counsel is ready to go, then we can get started with your witnesses. And before we got on the record, I did ask Mr. Hall if he wanted to change the order of his witnesses today, as he had mentioned yesterday. And I think his answer was that he didn't need to do that, but I will let Mr. Hall address that now.
No, that's accurate. That's accurate, Judge. There was a slight concern yesterday evening, but no, that's not a problem.
Okay, so did you want to introduce your first witness and I'll get that person sworn in?
Thank you, Judge. At this time, Public Counsel calls Mr. Robert Schoenberg to the stand.
Okay, and Mr. Schallenberg, I can see a video feed with that name on it. Could you raise your right hand, sir, and I'll get you sworn in. We'll make sure we can hear you. Do you solemnly swear or affirm that the testimony you will give in this hearing will be the truth, sir? And this is our first test. I'm going to need you to unmute, and then you're going to affirm once again that you're going to tell the truth today.
Yes.
Great, thank you. That works, and we can hear you loud and clear. You may proceed. Thank you. I think, Mr. Hall, you're muted as well, sir.
My apologies. Mr. Schallenberg, good morning. Could you please state your name and spell it for the court reporter?
Robert E. Schallenberg, Schallenberg.
By whom are you employed and in what capacity?
I am the Director of Policy for the Office of the Public Counsel.
And on whose behalf are you testifying today?
On the Office of Public Counsel.
Are you the same Robert Schallenberg that caused to be filed rebuttal testimony that has been pre-marked as Exhibit 200, both confidential and public versions?
Yes.
If I asked you the same questions contained in that testimony, would your questions be the same or substantially similar?
My answers would be the same, yes.
Do you have any corrections to make to your testimony at this time?
No.
At this time, Your Honor, I offer Exhibit 200 into evidence and tender my witness for cross.
Thank you. And did Mr. Schellenberg's testimony have confidential and public versions?
Yes, there was a public and confidential version. The confidential version is the one that our email system is too large to send, but both of those have been pre-filed in EFIS. If
Okay,
you need
and
those documents sent to you again, we can make that work.
I don't think that that will be necessary if you're offering the same documents that are in EFIS. I'm just clarifying that it's both versions.
Correct.
Okay, so OPC has offered Mr. Schellenberg's testimony in confidential and public versions as Exhibit 200. Are there any objections to that? Hearing no objections, that exhibit will be admitted to the record. As that would be 200 and 200C, I think is the way that we would do that. Okay, and do we have any cross-examination for Mr. Schellenberg from the National Housing Trust?
No cross-examination. Thank you, Judge.
Thank you. And all of your places have moved on my screen, so I'm looking at the wrong spot for people's faces. Is Renew Missouri, do you have any questions?
No questions from me, Judge. Thank you.
Does Counsel for Evergy have any questions for Mr. Schellenberg today?
No questions, Judge.
And Counsel for Staff?
No questions, Judge.
Missouri Industrial Energy Consumers? I did see Ms. Plesha's face earlier today. I hope she isn't having a connection problem. I will ask if Midwest Energy Consumers Group has any questions.
No questions, thank you.
Okay. Let me check my email to make sure there isn't a connection issue. Oh, it looks like we're okay. All right, and Sierra Club, Mr. Robertson, did you have any questions, sir?
No, thank you.
Thank you. All right, that would open up the opportunity for any commissioners to ask questions of Mr. Schellenberg. Were there any questions from the commission today?
No questions, Judge.
Thank you very much. And of course, if anything occurs to the commissioners, I know they're going to speak up and let me know that they need to say something. So I had a couple questions to ask Mr. Schellenberg. I wanted to hear your opinion in regard to General Instruction 7 and the application of that in regard to AAO applications before the commission. Is there anything that you would say about that, sir?
I think the General Instruction 7 is fairly clear. Now, on the other hand, it was never designed to be used as specifically as an AAO in Missouri guideline, but that's the way, once the commission adopted the Uniform System of Accounts, that General Instruction 7 is part of that. So that's how it becomes relevant to the proceeding.
Thank you. And I also wanted to ask you, which I think is also connected to that general instruction, which includes the provision regarding materiality and the 5% concept. If you were looking at that and trying to figure out the income figure that you would apply to evaluate that 5% standard, if it were accepted as such, where would you look to figure out what the income figure would be that you would apply in that analysis?
I would apply the net income amount for the period of which the event, the AAO, occurs or is occurring, and use that as a baseline. And then I would factor that up from down to 5%. to give and then factor it up for taxes, and that would give me a baseline of what materiality would be. And if it's under that baseline, it would not qualify to be material. And obviously, if it's over that baseline, it would be material.
So, and I understand that you were previously an auditor for the commission, so you're probably familiar with the kinds of reports that are made to the commission by utilities.
Yes.
Okay. So are there any specific reports or other sources that you're familiar with that are available to the commission that the commission could use for that purpose of determining net income?
Well, I would say the commission has an annual report filing from all the utilities. And in that, it gives net income for the respective utilities. So you could get the information from that. Now, there may be some difficulty in that it's only annual and it doesn't get filed until April or May with an extension. So there might be some lag in getting your hands on it. But like I know 2019 is available now.
Okay, thank you very much. Those were the only questions that I had. Are there any questions from the commission at this point? I have no indication that there are any additional questions. Is there any questions at this point from National Housing Trust for Mr. Schallenberg?
Oh, thank you, Judge.
And Ms. Plesha, it looks like you might have had a connection problem. So did you want an opportunity to ask questions of Mr. Schallenberg?
Well, first of all, thank you very much, Judge, for giving me the opportunity. My web connection went out twice. Both of the opportunities probably that I had to ask questions. I didn't have any questions, so thanks for asking, though.
Okay. If that happens to anybody during the hearing, just speak up and let me know, hey, I wasn't able to get in. That I'm sure everyone would appreciate knowing that and giving you an opportunity.
Thank you.
Renew Missouri, did you have any questions?
Not at this time, Judge. Thank you.
And Evergy?
Let's see. No questions, Judge.
Thank you. And any questions from staff?
No questions, Judge.
I just asked Ms. Plesha with Missouri Industrial Energy Consumers, so now I'll move on to Midwest Energy Consumers Group.
None, thank you.
And Sierra Club.
No, thank you.
Thank you so much. Is there any redirect from Office of the Public Counsel?
None, thank you.
Okay. So thank you very much, Mr. Schallenberg. That will conclude your testimony at this time.
At this time, Public Counsel calls Dave Murray to the proverbial stand. Dave, how is your audio and visual connection this morning?
This is Dave Murray. I have my audio on. I can try to start the video if you would like.
Mr. Murray, if you're able to, please do.
Okay. Okay.
Mr. Murray, by whom are you employed and in what capacity?
So let me swear in Mr. Murray first, please.
My apologies.
Good morning, Mr. Murray. Could you raise your right hand, please?
Yes, good morning.
Good morning. Do you solemnly swear or affirm that the testimony you give in this hearing will be the truth?
Yes, I do.
Thank you. You may proceed, Mr. Hall.
Thank you. Mr. Murray, by whom are you employed and in what capacity?
I'm employed by the Missouri Office of Public Counsel as a utility regulatory manager.
And on whose behalf are you testifying today?
On behalf of the Missouri Office of the Public Counsel.
Mr. Murray, are you the same Dave Murray who caused to be filed rebuttal testimony in this docket that has been pre-marked as Exhibit 201?
Yes, I am.
If I asked you the same questions contained in that exhibit, would your answers be the same or substantially similar?
Yes.
Do you have any corrections to make to your testimony at this time?
No.
Are the answers given in your exhibits true and accurate to the extent of your belief and knowledge?
Yes.
At this time, Your Honor, I offer Exhibit 201 into evidence and tender my witness for cross.
Thank you very much. Any objections to Exhibit 201, which is the rebuttal testimony of David Murray? Hearing no objections, that exhibit will be admitted to the record. Looks like we would start with any cross-examination from National Housing Trust.
I have no cross-examination for the witness. Thank you, Judge.
Thank you. Renew Missouri.
No, thank you, Judge.
Will there be any cross-examination from Evergy today?
Just a couple of questions, Judge.
And this is?
Mr. Zobrist.
Thank you. Please proceed, sir.
Good morning, Mr. Murray.
Morning, Mr. Zobrist.
Could you turn to page 2 of your rebuttal testimony?
Sure, I'm going to do something. Sure, page 2.
Yeah, page 2, your first question at the top of the page and your subsequent answer.
Yes, I'm there.
Okay. And you stated there that you believe that the commission should not approve Evergy's requested AAO or should at least exclude lost revenues in an approved AAO. Is that correct?
Yes.
Yes. And as we're sitting here today, is it also not correct that Evergy is not asking the commission to approve the AAO that it requested in its application?
That's my understanding with the stipulation agreement.
And the AAO application did seek deferral for lost revenues caused by the COVID-19 pandemic, correct?
Yes.
Okay. And by contrast, paragraph 6 in the non-unanimous stipulation and agreement provides that Evergy agrees not to defer into a regulatory asset any lost revenues from reduced customer usage due to the pandemic or other waived fees except as provided in paragraph 2D. Is that correct?
That's my understanding.
Okay. And therefore, the request of Evergy, as well as staff, MECG, MIEC, and the Sierra Club, meets your recommendation that if the commission does grant an AAO, the AAO should at least exclude lost revenues, correct?
That is correct for the at least.
Okay. Thank you, Mr. Murray. No further questions, Judge.
Thank you. Did we have any questions from staff?
No questions, Judge.
And Missouri Industrial Energy Consumers?
No questions, thank you.
And Midwest Energy Consumers Group?
Questions, thank you.
Okay. And Sierra Club?
No, Judge.
Thank you very much. So the floor is open to any questions from the commission for Mr. Murray. And I have a few questions that I'm going to ask Mr. Murray at this point, and then if the commission speaks up at all, they'll certainly have a chance. So, Mr. Murray, is it your opinion that the United States is in a recession at this time?
It's usually announced after the fact by Bureau of Economic Research. Yes, I believe they announced that we were in a recession fairly quickly. I don't know, they will announce the end of that when they deem, that they believe that the end of the recession occurred, and usually that's after the fact. So I really can't say whether or not that is something their opinion will be, as to when the end of the recession will occur.
Okay, so what you're saying is
To be determined.
Okay, so we get into a recession, but economists don't actually decide it's a recession until after we're well into it, and then they let us know when it started and when it ended.
Well, I believe the Bureau of Economic Research has announced that we're in a recession. As to when that recession will end, it could be last month. They have to analyze the data to determine when they believe the recession ended, and that's usually after the fact.
Okay, and then it sounds like you're referring to a specific opinion of a specific entity.
Bureau of Economic Research, correct.
Okay. And do you happen to recall what date that they attributed the start of the recession to?
I'm sorry, I do not.
Okay. And would you be able to provide any opinion about the causes of the recession?
Other than from sources, not firsthand, it would be relying on authoritative sources.
Okay. So do you happen to know what those sources are saying about what's causing the recession that has begun at some point and we aren't sure if we're out of it yet?
I mean, I'd have to take a look at the specifics from the Bureau of Economic Research, but more than likely it's either the pandemic obviously caused a lot of the lockdowns as far as mitigation efforts. So there's I think it gets to a point where it's loosely attributed to the pandemic, but is it the actual actions taken to try to mitigate the spread of the pandemic? I think you're probably aware of seeing cell phone mobility data as to whether or not people are voluntarily, staying in place. But so as far as whether or not it's the actual government lockdowns or voluntarily, I guess minimizing your movement.
Is there anything that you could say if you were comparing this recession to the recession that the economy went through in 2007, ending in about 2009 or so?
The 2007 to 2009 was, obviously a very prolonged recession, very much due to the great financial crisis, very much a structural financial collapse. This recession is obviously attributed to the public health and actions taken to address the public health situation, which obviously you see the debates on the potential V-shaped hockey stick, K-shaped types of recoveries, but yes, that definitely was very fast and steep decline in the second quarter. The classic definition of a recession is 2 consecutive quarters of decline. I say classic textbook definition. That's not the Bureau of Economic Research's specific definition. But the point being is that it was a very long recovery in the 2007 to 2008, 2007, 2009 recession and a great financial crisis, which seemed to have a very long lasting impact.
And I have asked a few witnesses about where they would look if they were trying to figure out net income or income in reference to the materiality standard that, if that term is fair to use in regard to General Instruction 7. So I'll just go ahead and ask you that question as well. Is there a particular place that you think the commission could look to figure that out?
It depends on how current you want the information to be. As far as, I guess going into this case with 2020 being the period that's being evaluated, you could just look at the year end 2019, compare the annual reports filed with the Missouri Public Service Commission, the annual reports filed with the Security and Exchange Commission, and also the information that's filed for the fuel adjustment clause filings for surveillance.
Okay, and I have one more question for you. Are you aware of what percentage of arrearages owed to Evergy were ultimately converted to bad debt for these companies before the pandemic? Is that information that you have?
Sorry, I do not know that.
Okay. All right, so let me check my email and see if I have any messages. Looks like I'm done with my questions. We can go on to any recross. If there's anything from National Housing Trust
Oh, thank you, Judge.
and Renew Missouri.
No questions, thank you.
Anything from Evergy.
Just briefly, Judge. Mr. Murray, the Bureau of Economic Research, is that part of one of the federal government departments?
Yes.
Is it the United States Department of Commerce?
I don't know.
Okay, but the agency that you referred to is a federal agency that's part of the federal government. Is that correct?
Yes.
Okay, and do they periodically issue authoritative reports upon which experts like you and others rely upon as authoritative?
Yes.
I'm sorry, Mr. Murray, was
Sorry,
that
yes.
a
Yes.
yes? Okay, great. Thank you very much. That's all I have, Judge.
Thank you. Do we have any requests from staff?
No cross, Judge.
Thank you. Anything from Missouri Industrial Energy Consumers?
Yes, I have a couple of questions for Mr. Murray. Good morning, Mr. Murray. How are you?
Good morning. How are you doing?
I'm doing fine. I wanted to follow up on a couple of the judge's questions about income and the FAC surveillance reports. Can you tell me how often those reports are filed?
Quarterly?
And what categories or types of information are included in that report?
Basically, anything that allows you to assess the financial performance of the company, as far as real-time data and more or less in a, I guess, in how it may be evaluated from a rate-making perspective, as far as what the authorized rate of return is, how they're doing, in comparison to the authorized rate of return. So it's basically an income statement, a balance sheet assessment that allows you to determine whether or not there's any concern as to whether or not the fuel adjustment clause is I guess necessary from a perspective of allowing higher earnings than are allowed, and also lower earnings than are allowed.
Do you think it's fair to say that one of the purposes of the FAC report, surveillance report, is to monitor the earnings of the company?
Yes, that's what. Sorry, I
I just trying to encapsulate what you said. I don't have any further questions. Thank you.
Ms. Bench, are you okay? Was that too garbled for you?
Could, just to be clear, if she could repeat that last question.
Sure. I think the last question I had was, is it fair to state that one of the purposes of the FAC surveillance reports is to monitor the earnings of the company? That was my last final question.
And Mr. Murray?
My answer was yes.
I'm sorry if my audio isn't coming through clearly.
I think you just had an intermittent problem. I think it's okay.
Thank you.
So then I think we're ready to proceed to any questions from Midwest Energy Consumers Group, if you had any.
No questions.
And Sierra Club?
No, thank you.
Thank you. Is there any redirect from Office of the Public Counsel?
Yes, briefly, Judge. Mr. Murray, in response to questions from the bench, you referred to a K-shaped recovery. I would like you to expand on that. What do you mean by K-shaped?
A K-shaped is the view that that the higher socioeconomic classes of the of our economy will rebound quicker than the lower income class of the economy.
And why is it referred to as K-shaped?
Because the wealthier would experience a rebound quicker than the lower income. So the upper part of the K represents the higher income, higher wealth aspect individuals in the economy, and the K, the lower part of the K, is the lower income, individuals that in the service sector that work from paycheck to paycheck.
So the data looks like a K if we put it on a graph.
I say the data. It's more. I'm not going to say this is an official. This is not an official. I guess GDP, because it bifurcates. It's trying to break up the potential rebound of the economy into different different classes of wealth and income in the economy. So it's not going to be an official, I guess, authoritative type of graph, if you will. It's just used to explain what happens when you have a situation like we just have had, where the service workers have been the most impacted by the lockdowns.
Do you think the Evergy's requested AAO in the form of the stipulation and agreement exacerbates or moves away from the K-shaped recovery?
It's obviously utility customers that that have problems with paying their bills are probably in a lower socioeconomic status. So that would exacerbate, if to the extent they have increased costs put on them.
Thank you, Mr. Murray. No further questions.
Thank you, Mr. Murray. That will conclude your testimony.
Thank you.
At this time, I would call for the availability of Dr. Jeff Mark.
Okay, and there I see a video feed for Dr. Mark. It looks like the line is muted, and he should have the ability to unmute the line. It might be on the video screen. Oh, there we go.
Here we go.
Okay. So, Mr. Mark, can you raise your right hand, or I'm sorry, your doctor. Dr. Mark, can you raise your right hand for me, please? Do you solemnly swear or affirm that the testimony you will give in this hearing will be the truth, sir?
Yes.
Thank you very much. You may proceed, Mr. Hall.
Dr. Mark, by whom are you employed and in what capacity?
I'm the chief economist with Missouri Office of Public Counsel.
And on whose testimony are you, on whose behalf are you testifying today?
The Missouri Office of Public Counsel.
Are you the same Dr. Jeff Mark who caused to be filed your two exhibits that were pre-filed, marked as Exhibit 202 and 203, the corrected rebuttal testimony and surrebuttal testimony, respectively?
Yes.
If I asked you the same questions contained in both those exhibits, would your answers be the same or substantially similar?
Yes.
Are the answers contained therein true and accurate as to the fullest extent of your belief and knowledge?
Yes.
Do you also have proposed corrections to your testimony?
I do.
And did you have those corrections conveniently done beforehand as an exhibit pre-marked as Exhibit 204?
I did.
And that is your errata sheet?
That is correct.
And once we incorporate the changes in Exhibit 204, are there any other changes you need to make to your testimony?
No.
Your Honor, at this time, I move for the admission of Exhibits 202, 203, and 204, and tender Dr. Mark for cross.
Thank you very much. So 202 is the corrected rebuttal testimony of Dr. Mark 203 is the Sir Rebuttal Testimony, and 204 is the errata sheet. Are there any objections to those exhibits being admitted to the record? Hearing no objections, those exhibits will be admitted. So we would proceed then to any cross-examination, starting with National Housing Trust.
Thank you, Judge. I have a few questions.
Okay, please proceed, sir.
Good morning, Dr. Mark.
Good morning.
So, Dr. Mark, I want to start with a question about the working docket, the COVID-19 working docket. Can you explain how you have personally been involved with stakeholders in this docket?
Well, the Office of Public Counsel did file comments in the working docket, the Commission's working docket, to deal with arrearage payments. But even preceding that, we've been working with all of the utilities and various stakeholders on weekly COVID-19 phone calls.
And would you say you have concern about the empirical data you've seen about the spread of COVID-19 and utilities' responses to it?
There's a lot of noise in the data. There's a couple factors, you need to consider based off the empirical data that we've got. One is there's a time issue, that there's a lag of at least about a month before we get an accurate sense of what's taking place with the utilities. So, for example, right now, we're still waiting on October data. And, at best, I'm able to go ahead and give a sense of what was the world like for utility customers back in September, which was also the same time when customers were getting various stimulus safety net relief checks in place. And a lot of that has dried up since then. So, here we are at mid-November. It is much more difficult to go ahead and gauge.
Yeah. Okay. You discussed the lag. What about utilities arrearage amounts, and specifically Evergy Metro and Evergy West's arrearage amounts? Do you have concerns there?
The arrearage amounts across utilities has increased. That's, without a doubt. I think that there's a misconception with what's taking place as far as disconnects and arrearages. A lot of people perceive that there would be this mass tsunami of disconnects that would take place as soon as the moratorium was lifted. And the reality of it is that the payment plans have increased about fivefold. So across the board, you're having huge increases in payment plans. But with that, month over month, the arrearage amounts have increased considerably. I have a lot of concern about Evergy in particular, both in particular Metro and West, but in particular Metro. The average residential arrearage amount is categorically higher than any other utility in Missouri right now. There's probably various reasons for that, but moving forward, of all my utilities, those are both Metro and West are my biggest concerns in terms of sheer dollar amount of arrearage that needs to be overcome.
Yeah. Okay. So you referenced payment plans. Can you explain your opinion on the importance of arrearage management plans or payment plans, which we've heard a lot of testimony about? And in particular, like, what is the value of these plans for shareholders and for ratepayers, in your opinion?
Sure. There's a twofold purpose, I would say. I mean, there's value for both shareholders and for ratepayers at the end of the day to ensure that arrearage amounts are as low as possible. If those arrearage amounts are not brought down, if they're let to lag, or if they're increased over time, eventually those arrearage amounts will be uncollectibles. And today we have, rates are set to account for some of that. The big concern, and this was referenced a lot by Evergy's witnesses yesterday, was that big tail and that big tail that might take place, later down the line, that could expose the company and potentially customers to this large uncollectible amount. I mean, this is a concern for all utilities. This was a concern with Spire. This was a concern with Missouri American. And this is where arrearage management plans are so important. Because at the end of the day, you're going to have to pay one way or the other. We're either going to have to pay at the end when we settle rates with those uncollectible dollars, or we can be proactive and try to mitigate that problem today. And that's what we came up with the Spire case. That's what we, proposed here with Evergy, because we really feel like, at the end of the day, it is beneficial for both shareholders and ratepayers. Let me emphasize the shareholder aspect on it, because there's been a lot of lip service given to lost revenues here. If you're keeping customers on, they're paying down their bill, you're going to have less lost revenues as well. I mean, it's a feedback loop that's taking place across the system. So our office has been a big proponent of trying to enable customers to take advantage of existing stimulus that's out there, but also to try to bring down what can be a really psychologically large arrearage amount. So, and the last point I'll just say is that this is really just trying to emphasize the we're all in it together approach. I'm very thankful that Spire and Missouri American did take that approach. I do have a lot of concerns with how Evergy has handled it to date.
Okay, so you referenced the Spire and the Missouri American Water case. Public counsel entered into the unanimous stipulation agreement in the Spire case. Is that correct?
That's correct.
And can you explain what was different in that case and why public counsel has not joined the stipulation in this case?
The two biggest things. The first one is the gambling provision that my counsel referenced earlier. We just think that's unfair at the end of the day, especially considering everything that's taken place. It seems I question how we, first of all, I question how we could agree to something to better terms with Evergy than what we agreed to with Spire and Missouri American. But the gambling provision in particular, the idea of the company saying, we want to leave the door open. If things get really bad, we're going to be sheltered with this risk, but we want to cease being aggressive or continuing to offer payment plans or arrearage management plans. It seems wrong. I mean, period. And the second part is the arrearage management plans. Or in Missouri American's case, it was bill credits. But for a company that has the largest arrearages in the state of Missouri right now, I mean, categorically larger than other utilities, to not continue to pursue arrearage management programs, that show, both company and ratepayers are in it, seems wrong.
And regarding that arrearage management program, that agreement reached in the Spire case, can you explain how parties arrived at the amount and the matching framework there?
I can. In general.
Judge, I'm going to object here. I think these are confidential settlement discussions.
Judge, understood. I'm not trying to elucidate the figure that was arrived at, but merely the process by which parties arrived at that. And I don't believe the framework of the matching program is confidential.
And Judge, if I may respond to what Mr. Lanier said, I would agree if he's talking about the framework that's in the public document, that's not confidential. But by his own words, referencing the discussions that got there, those would be confidential.
Okay, fair enough. I will withdraw the question and reframe.
Okay, go ahead.
Dr. Mark, can you explain what public counsel finds valuable in the both the figure dollar amount and the matching framework that you've agreed to in the Spire stipulation?
In the Spire stipulation, it specifically spells out that the balance of annual energy efficiency funds that were unspent would be matched. A certain dollar amount, both that were allocated on the residential side, would be matched by the company for an additional $1 million and used to help customers pay down overall arrearages. So if a customer had an arrearage dollar amount, let's say, they were at $200 and, they were at threat of getting disconnected. They could enter into this plan, if they showed that they were harmed by COVID in some manner, and they would immediately get a $100 credit that would be expunged from their balance. And then from there, dollar for dollar, it would be matched. So if that customer donated $1, an additional $1 would be donated through this program. And as long as the customer was remaining current, they could pay down their balance. So that was the impetus behind it, because we saw, obviously, that the heating season was about to begin, and we wanted to get that approved as quickly as possible so customers could take advantage of it.
Okay. And to your knowledge, has the commission approved a matching payment arrangement like this one in an AAO case or in another case?
The framework of what I suggested here in testimony back in, I guess, July, was the same framework that the commission approved for Liberty Utilities when they acquired Empire District Electric Company as part of that document.
And just briefly, what about the Missouri American Water case? Why did they utilize a bill payment program rather than this matching program?
The short answer is that the Missouri American customers weren't as negatively impacted, or the company in terms of arrearage amount and number of customers on payment plans wasn't as pronounced as it was for the gas, and certainly not as pronounced as it is for electric. So given those factors, we felt
I'm
like
sorry,
it was...
Dr. Mark? Could you
Yes.
go back a little bit with your answer? I had a hard time understanding you.
Sure. For Missouri American Water, customers for Missouri American Water were not as have not been as negatively impacted as customers, as natural gas or electric customers. The Missouri American customers in particular, it was just the bill credit seemed like a more forthright, quicker way to go ahead and serve that K-shaped sub-demographic that Mr. Murray referenced.
So, Dr. Mark, if we're trying to arrive at an equivalent dollar amount for Evergy, if they were to adopt the matching arrearage management program like the one you've proposed in this case, what would you estimate that being based on the dollar amount in Spire?
Oh, I given their sizes, I would say about $1 million per company.
So $2 million
is an approximate number. Yes.
Okay. I want to ask you a couple questions about the Evergy's payment plans. They have a 1, 4-month, and 12-month payment plan. We had testimony about that yesterday. I believe the 1 and 4-month payment plans ended this summer, and the 12-month payment plan ends next month. Is that your understanding?
The 1 month and 4 month payment plans ceased getting applicants. They ceased any new applicants in August.
Okay.
Right, and the 12-month plan is essentially the cold weather plan, which allows for 12 months. So really all Evergy has done is started that cold weather option earlier than would otherwise take effect here 2 weeks ago.
Okay, great. And I'm looking at your rebuttal testimony here on page 17, around line 16. Do you have that in front of you?
1 second. I've got two monitors here. Page 17.
Yeah,
I'm on
and
there.
I'm looking at a table that says payment arrangement credits by program. Do you see that?
Yes.
So I'm just wondering, do you have any concerns about how Evergy has operated its customer arrearage payment program that was in place earlier this year, the current one?
Yes. So Table 2 is a really good example of that. It is obviously missing August, but if you look at those 2 months, and we were saying June, July, and then we're missing August. That's it. We had roughly under 100 days of where there was a payment plan arrangement in place during summer. Then it stopped. For those 2 months, you have 1,129 customers that were able to take advantage of it. So, one, this is a very, very small amount relative to the overall population of customers that are in arrearage. Two, it's already done. And it's done before stimulus bills, but really before you see that pronounced K dive of customers that are making, at or near, let's say 200% of federal poverty line. Three, my big concern with this is that this whole overall design is what I would characterize as one that's probably largely filtered by free riders. And what I mean by that is customers that would have paid their bills regardless of whether or not there was a 1 month or a 3 month option. Our concern is not customers that could pay their balance in a month. Our concern is customers that aren't going to have their job, for a prolonged period of time. Our concern is customers that, are going to be, at risk of losing their power over the winter.
Right.
That's the big concern. This payment arrangement is I applauded the company insofar as coming forward with something, but the design itself is flawed.
Okay, and regarding the design of these payment plans, I want to ask, let's say a customer is out of work. They have been out of work for a while. They're struggling to pay their bill. Say they've signed up for the 12-month payment plan. In your understanding, what happens if a customer misses a payment?
Well, that's a bit of a general argument, or I guess a question. It would depend on what point. Was this their first missed payment? Did they miss something before they entered into this arrangement? Is there any matching funds? Is it during the cold weather rule where
Right.
they could or could not be shut down? There's some variables, I guess, at play there.
Yeah, I mean, in your understanding, is there a way for a customer to be kicked off of the payment plan, I suppose?
Sure, by non-payment, right.
Okay. I just have a couple questions about Evergy's economic relief pilot program, which has been the subject of your testimony and others. I'm looking at your sir rebuttal on page 6. And lines 11 through, let's see, page 6, lines 11 through 14, you're talking about the ERPP, or the Economic Relief Pilot Program, and how the program's had an uptick in participation. And in particular, you, in your footnote there, I'm wondering if you could just summarize the footnote that you put in your testimony there.
This is from 2 rate cases ago. The footnote cited the concerns that we had with the company not being able to spend the economic relief pilot program dollars, which was largely a 50-50 sharing mechanism between ratepayers and shareholders. There was a pretty high-profile story at the time about a grandmother who was looking after her granddaughter that was on various different medical equipment that was getting their power shut off. But even through notes from the hospital, they had difficulty. They were still going to get their power shut off. But yet we had this ERPP money and others available. So our concern with the Economic Relief Pilot Program, and this was a recommendation by Mr. Colton to increase the funding for the ERPP, was that we haven't only spent down the ERPP money that we've had in the past. And in fact, there's a lot of reasons that came of it. It's at the time in that rate case, if I recall correctly, the Salvation Army, and the Salvation Army, I believe, is still providing it. But when we reviewed the Salvation Army's website for the ERPP money, we noted that the terms of the program on its website were different than what was in the tariff. So there was a lot of organizational structural problems, and it underscored our concern about getting money to the people that need it.
And would that concern continue or even be higher, I suppose, during this COVID crisis?
Very much so. I know the company had referenced CSR dollars, that the money they had given their customer service reps. And that's all below the line, and I applaud the company for doing that. I also really have no sense of how much money that was, what the terms were surrounding that, the basis for that. Did a customer just call up and I guess, what did they have to say to elicit a certain dollar amount? And there was a lot of discretion given to the reps themselves. I guess the concern there is just the uncertainty. I just don't know. And it's not a very transparent process. That's it.
Okay. So some parties, in particular staff and the company, have suggested that customer payment plan arrangements aren't appropriate, or they're not traditionally a part of AAO proceedings. Do you agree with that statement?
I struggle with staff and the company's position on customer arrearage payment, just taking the position that it's not appropriate to talk about this stuff or to have it in there, but yet including this 1 month and 4 month customer payment plans in the STIP. I don't know how that works. How they can take that position, but yet include the stuff that we did for 3 months this summer in it. So, make no mistake about it. Like, this is the worst time right now. Right now, what's taking place as we enter into the cold and flu season, and you can see that with the number of COVID cases increasing, and the arrearage figures increasing on top of that. So I think it's absolutely appropriate. It's seemingly what's appropriate for an AAO. There's a lot of discussion about that, whether we're talking about materiality or I would say the reoccurring factor here. So this is a loose definition at this point, the commission's working definition.
Dr. Mark, were you present and listening to the testimony of Mr. Chuck Casely for Evergy yesterday and his cross-examination?
Yes, I did hear it.
Okay. There was discussion about some of Evergy's customer programs and grants. Mr. Casely in his testimony was clarifying that the $2.2 million in shareholder funds that also Mr. Fisher, counsel for Evergy, addressed in his opening. Mr. Casely clarified that was split between Kansas and Missouri customers basically on a customer count basis. Could you estimate how much of that $2.2 million would be allocated to Missouri? in particular
I-
residential Evergy customers?
So there's about it ebbs and flows a little bit, but it's about a 60-40 split. It's about 60 Kansas, 40 Missouri. So if we said 2.2 million across both states, it's going to be about $1 million. And of that $1 million, that's allocated in 4 different buckets. Most of those buckets are going to the grant programs, like the Kansas City Ballet, the Chambers of Commerce, and so forth. And then you've got a bucket for dollar aid. If I was ballparking it based off of those numbers, it looks like about 400,000 for dollar aid. That's what I would say. And that's what we're talking about. We're talking about $400,000 based off of those numbers that has been allocated to date for bill credits for customers.
Okay, so of that 2.2 million that we've seen in testimony, you're saying that less than a quarter of it would actually go to bill aid for residential customers.
Right.
Okay. Just 2 more questions here. Do you know how much money Evergy made in tariff revenues in 2019, roughly?
I do. That is actually information that the annual reports. That's something that there's a concurrent case that we're working on a workshop where that information has come up. But it's about well over $1 billion, close to $2 billion. I would say 1.7 and $5 billion between the 2 utilities tariff revenues for 2019.
Okay. And just to remind us, can you remind us how much you estimated the arrearage management program that you recommend would cost?
$2 million.
Okay. Okay, I have no further questions. Thank you very much.
Thank you. Is there any cross from Renew Missouri?
No, thank you, Judge.
Does Evergy have any cross today?
Yes, please. This is Rob Hack.
Thank you.
Good morning, Dr. Mark.
Good morning, Mr. Hack.
So we'll start with the last question. You were addressing revenues for the Missouri operations of Evergy, correct?
Yes.
That is not earnings, correct?
That is correct.
So the lion's share of those revenues are used to support the company's cost structure?
Yes.
Do you have the non-unanimous settlement with you, Dr. Mark?
I do.
Would it be, I'm going to refer you to paragraph 16. And in particular, the last 2 sentences of that paragraph, and I'll try to cut to the chase. Are you there?
I am.
And has the company and the joint signatories to the non-unanimous stipulation agreement set forth the company's agreement to evaluate the advisability of extending the offering of 12-month payment plans beyond the end of the calendar year for small business customers and beyond the end of the cold weather rule period for residential customers in consultation with staff, OPC, and NHT after the first of the year?
That's what it says.
Now, the cold weather rule does not apply to small business customers, correct?
Correct.
So the company's continued offering of 12-month payment plans to small business customers in November and December is not required by the cold weather rule.
That's correct.
Then the last sentence of paragraph 16 of Exhibit 1 says, in addition, the company agrees to evaluate the advisability of offering additional customer assistance programs after December 31. It says 2021, but it was corrected to 2020 in consultation with staff, Office of the Public Counsel, and National Housing Trust, correct?
That's what it says, yes.
In your discussions with Mr. Linares, you looked at page 17, I believe, of your rebuttal testimony and a table on that page. Do you remember that?
I do.
And that page speaks to the 1 and 4 month payment plans that the company offered during the summer, correct?
That's correct.
The payment plans that are referenced there, the numbers, don't include the 12-month payment plans that the company has been offering since basically the pandemic began. Is that correct?
There are no incentive payment plans for the 12 months.
That's not what I asked you, Dr. Mark.
Well, that table does not include the 12 months. That table is to show the payment arrangements that are in place for the incentive programs.
Okay, and fair enough. But the table doesn't show the 12-month payment plans that the company has entered into with customers throughout the pandemic and continues to enter into, correct?
Correct.
And are you aware that the vast majority of payment plans that customers have entered into, when you consider the incentive payment plans that are referenced on page 17 of your rebuttal and the 12-month payment plans, that the vast majority of the payment plans that our customers have entered into are the 12-month payment plans?
That's the only plan that's available right now.
That's not the question I asked you. Since the beginning of the pandemic, thank you. And in your discussion with Mr. Linares, you mentioned the long tail of uncollectibles. And is that at least partially in relation to the length of these payment plans?
Well, we don't know. I mean, that long tail, that long tail is a projection moving forward. We're assuming there's going to be the potential for a long tail come spring. I think that there's a chance that could be a very long tail.
Yes, I don't want to.
I guess I'm trying to understand the question.
Yes, I guess I'm trying to ask you, is part of the cause of that potential long tail the fact that there are these 12-month payment plans, lengthy payment plans?
Sure. If there was not a 12-month plan, people would be disconnected.
And Dr. Mark, would you also agree that another cause or potential cause of the potential long tail for uncollectibles is the fact that there's a cold weather rule in Missouri that places significant constraints on the company's ability to shut off for non-payment between November and March of each year?
Could you repeat the question for me, Mr. Hack?
Yes. Would you also agree that another potential cause of the potential long tail of uncollectibles in relation to the pandemic is the fact that there's a cold weather rule in Missouri that precludes the company in significant respects from disconnecting customers for non-payment during the winter months of November through March?
I would not agree with that.
So do you understand how net write-offs occur on the company's books?
Yes.
And is it your understanding that net write-offs only occur for an account after the account is shut off for non-payment?
Correct.
And occurs some period after the shut off for non-payment, correct? 60 to 90 days? Correct. And if the company cannot shut off for non-payment to a significant degree, weather-related, during the winter months, net write-offs as a result of that lack of shut-off activity are not going to be very high, are they?
Then if there was no cold weather rule?
Correct.
If there was no, you're right. If there was no cold weather rule, there would be more disconnections. I would say that the cold weather rule has been in place since the 70s. And essentially, at this point, rates have been set to account for that. So
have rates been, I'm sorry. I didn't mean to interrupt.
We're talking about close to 50 years of the cold weather rule in place at this point. You know, when we set rates, we're setting rates with a certain sense of an average dollar amount of uncollectibles that based off of the historical average. If there was no cold weather rule, it would be more pronounced.
I apologize again. Are you done?
The challenge.
So are you done? So let's talk about the way rates have been set over the past 50 years. And in particular, maybe in GMO and Evergy, Missouri Metro's last rate case. To your knowledge, was the company offering 12-month payment plans during the summer months when the net write-offs were looked at in that last rate case?
No.
And there wasn't a pandemic ongoing when the net write-offs were looked at in the company's 2018 rate cases, correct?
Correct.
Would refer you to your rebuttal testimony on page 5, I think starting on line 16. I'll let you get there.
I'm there.
And you recommend there that the commission require Evergy to offer a dollar-for-dollar matching arrearage management program. Is that correct?
That's correct.
And also on the next couple of pages, 6 and 7, you endorse expansion of Evergy's economic relief pilot program, correct?
I wouldn't go so far as to say it was an endorsement of the ERPP.
How would you characterize it?
I would characterize it as a response to NHT's request to increase the dollar amount. My testimony spelled out my criticisms of that program and my skepticism about the program moving forward. And then I made a blanket comment or recommendation that if the commission elects to move forward with something like this, then we would ask the shareholders bear that, not ratepayers, based off of my concerns articulated earlier.
Fair enough. So your recommendation for a dollar-for-dollar matching arrearage management program and your, I'll characterize as a lack of opposition to NHT Witness Colton's recommendation to expand the ERPP both of those positions you expressed are conditioned on the booking of the associated costs below the line, correct?
Yes.
And by below the line, you mean that Evergy shareholders would be required to absorb the cost of these programs without the ability to seek recovery in rates, correct?
That is what my testimony said.
And Evergy has made you aware that it objects to being required to offer these programs due both to the absence of just compensation and the fact that it would usurp management authority and discretion. Is that correct? Meaning our view is that those things?
Yes.
Thank you. Do you perchance have the Spire and Missouri American Water settlement agreements with you?
I could get them fairly quickly. Which one would you like me to look up first?
Maybe Spire.
One second. I'm going to put my phone down.
Okay, thank you. Are you there?
Almost. It's loading right now.
Okay.
All right, I'm there.
I would ask you to look at the last sentence of paragraph 19 on page 8 and just read that last sentence into the record. And this is the Spire stipulation and agreement in case number GU-2020-0376.
I pulled up the wrong document. Hold on one second. Joint. We've got the motion for expedited.
I think it might have been. I'm sorry.
I got it now. Here. Is it the amended unanimous stipulation agreement?
Yes, sir. Sorry.
Okay.
So page 8,
All right,
paragraph 19, last sentence.
All right, I'm there. Duration of AAO?
No, it's page 8, paragraph 19. What document are you in, Dr. Mark?
Interdependence.
No, it's limitation of scope. It's the paragraph immediately above interdependence.
I'm there now.
So the last sentence of paragraph 19.
The signatories further understand and agree that no party to the stipulation and agreement shall assert the terms of the stipulation as a precedent in any future proceeding.
Okay, thank you. Can you go, let me ask you one more question about Spire. Prior to the execution of that agreement, are you aware of whether Spire had made any charitable contributions on account of COVID akin to the $2.2 million we've been discussing that Evergy made available in both states?
I'm thinking. I don't know.
And I would also ask you, with respect to Spire, prior to the execution of this AAO agreement, had Spire offered incentives for customers to enter into short-term payment plans due to the pandemic?
No.
Okay. Thank you. Can we move to the Missouri American settlement agreement?
Yes.
You want a case number?
I've got it.
Okay.
All right, I'm there.
Page 7, paragraph 18.
Okay.
Would you read the last sentence of that paragraph, please?
Other than as explicitly provided herein, none of the parties shall be prejudiced, or bound in any manner in this or any other proceeding by the terms of this non-unanimous stipulation and agreement, regardless of whether this non-unanimous stipulation and agreement is approved.
Thank you, Dr. Mark. Now, with respect to Missouri American Water Company, prior to the execution of this stipulation and agreement in case number WU-2020-0417, had Missouri American Water made a charitable contribution on account of COVID akin to the $2.2 million Evergy charitable contribution that has been discussed today?
Missouri American Water, I believe, I don't know the exact dollar amount. Anywhere between $200,000 and $500,000 was included for their H2O program, bill credit program, prior to entering into the non-unanimous stipulation and agreement.
And that was COVID
I'm sure it's on their
related?
website. Yes.
And had Missouri American Water Company offered any incentives to their customers for entering into short-term payment plans on account of COVID, as we've discussed, that Evergy did?
I don't know. I know Missouri American had the longest disconnection moratorium in place. And I can't speak to whether or not I know that they made bill payment arrangements. I don't know if they accepted a 12-month or not.
I'm asking you about incentives for entering into short-term payment plans?
No.
I just want to look at my list here. I think that's all I have. Dr. Mark, thank you very much.
Thank you.
Okay, thank you. I apologize, but I'm going to have a 10-minute break. So we will come back at 10:33 a.m. and resume. I apologize, Dr. Mark.
Not a problem. Thank you.
Okay, thank you. We are off the record for 10 minutes. hearings press on whether or not we're able to stream. So we're going to keep on going. If you have folks outside of this hearing that needed to hear it, that audio is down. So,
Judge,
yes.
it's Justin McKenzie.
Mhm.
I think I have the audio working again. It just FYI that the last probably 5 minutes was not recorded.
Okay,
So
we have a
don't
court
that.
reporter here, so we're okay.
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 Thank you.
Thank you so much for helping us out. Is there someone else trying to get in? Okay, it's just an echo. So we were ready to move on to recross for Dr. Mark, and we would start with National Housing Trust, and I'm going to try to figure out, Ms. Plesha, I think that's your line that's causing that problem.
Oh, I'm sorry.
It's okay. All right. So,
Sorry, Judge. I just wanted to confirm. I just checked. The audio appears to be back on the stream.
okay, great. So thank you, Justin McKenzie, for helping us out and getting that audio back up. And now we're ready for recross. National Housing Trust, do you have any?
Thank you, Judge. I have no recross.
Okay, thank you. Anything from Renew Missouri?
No, thank you, Judge.
Evergy, did you have any recross?
No, Judge. Thank you.
Thank you. Anything from staff? And I saw you nodded no, but it cut you off, but I understand you, so we're okay. Missouri Industrial Energy Consumers?
No questions, thank you.
Thanks. Midwest Energy Consumers Group?
No, Your Honor.
And Sierra Club?
No, thank you.
Thank you so much. Is there any redirect for Dr. Mark from Office of Public Counsel?
Yes, briefly, Your Honor. Dr. Mark, do you recall Mr. Hack questioning you about Evergy's position? And I believe he used the phrase usurping management authority.
Yes.
Do you agree, or do you understand that to mean that Evergy has a position that there are certain things that the commission cannot order the company to do?
Yes.
For the purposes of these next few questions, I want to stipulate that when I say MIA, I am referring to Missouri's Energy Efficiency and Investment Act. Dr. Mark, are you familiar with, or let me rephrase that. Dr. Mark, did Evergy recently apply for a portfolio of MIA programs?
Yes.
And did the commission approve those programs?
Yes.
Objection is well beyond the scope of my cross.
If I may respond, the questioning will ultimately get to the relation, which is the company's position on usurping management authority.
I think we need to hear a little bit more before we know. So you can proceed.
I forgot, Dr. Mark, did the commission approve Evergy's requested MIA portfolio programs?
Yes.
Did the are you familiar with PAYS or Pay As You Save?
Yes, I am.
Did the commission approve Evergy's programs, but then condition that approval on Evergy approving a PAYS program?
Yes, they did. The company had was granted a MIA application on the condition that they move forward with a PAYS program within its cycle. So that was acceptable to the company.
To your knowledge, did Evergy challenge that order or appeal it?
No.
No further questions.
Can you provide a case number for this proceeding that you've referred to, Mr. Hall?
Sure. The number is EU-2019-0133. It's a companion 33 and 32, I believe. Dr. Mark, am I right on those numbers?
I'm looking them up. Can you repeat them again, Mr. Hall?
EO 2019-0132, and I cannot recall if the companion case is 33 or 31.
It's 33.
Thank you.
Okay, so Mr. Hack you'd objected that I guess you were making a relevance objection.
I was objecting because it exceeded the scope of my cross.
Okay.
But I withdraw the objection.
Okay, thank you. So essentially, Mr. Hall, you're drawing a parallel to a different proceeding and trying to make an example of another condition that has been attached when an application was made. Is that right?
That is my attempted implication, yes.
Okay. All right. So I believe that should conclude Dr. Mark's testimony today. So thank you very much, sir.
Thank you.
And I believe that's the conclusion of the Office of Public Counsel's witnesses. Is that right?
Yes, I guess we're good, and Mr. Linares is up to bat.
Okay, I do have some questions possibly about exhibits that were on your list, but were not offered. So because we've just finished your witnesses, it would be convenient for me as the judge to discuss your exhibits. Is that okay with you, Mr. Hall?
Of course.
Okay. So, and you actually had the most interesting exhibit list of all the parties. So that's why you're going to get more attention. So you did, we have offered and accepted the Schallenberg testimony, which is 200 and 200C. And then we have the Murray testimony, which is 201. 202, 3, and 4 are in regard to Dr. Mark, and those have come in. It looks like earlier in the proceeding, you did offer a data request that is your 205. Is that right?
Correct.
And then actually, Evergy offered the 206, 207, 208 exhibits, and they have been admitted. However, that leaves 209 and 210. And I'm just following up with you to clarify whether those are still being offered or how you're approaching that.
No.
Or if you want me to just refer to that. Okay, go ahead and explain.
Judge, I apologize for any confusion. I wished to pre-mark as many exhibits that I anticipated using at the hearing, or at least there was the potential of using them throughout the course of the hearing, just based on the flow. I had realized I had no reason for 209, and I had used 210 merely as an aid in having a conversation with the witness. I don't object to offering those exhibits into the record, but their purposes were rather limited, and ultimately I thought it was better when devising how to approach this hearing for people to have more notice of what was a potential discussion versus dropping more and more exhibits last minute through the course of a virtual hearing.
Thank you. And I agree with that approach 100%. I just wanted to make sure that I didn't miss anything that I can't have clear up with you later. So 209 and 210 really haven't been offered, and they won't be exhibits that you're offering in this hearing. And I just wanted to clarify that.
Correct.
Thank you very much. Okay, so I think that does leave us with one witness this morning, and that's Mr. Colton. Is everyone ready to proceed with that testimony, or does Ms. Bentz need a break before we get to our last witness? Okay. So, and I thought I saw Mr. Colton's name on the screen at some point.
I am here, Your Honor.
Okay. And so is Mr. Colton going to be appearing with audio only? Oh, I see you. I apologize. There you are. It's okay. I see Mr. Colton there. All right. So would you please raise your right hand, sir, and I'll get you sworn in, and then I'll pass you off to your attorney. Do you solemnly swear or affirm that the testimony you will give in this hearing will be the truth, sir?
I do.
Thank you very much. Mr. Linares, you may proceed.
Thank you, Judge. And good morning, Mr. Colton. How are you?
I'm doing well.
Can you tell us by whom you are employed and in what capacity?
I'm a principal in the firm of Fisher, Sheehan, and Colton.
And on whose behalf are you testifying today?
I'm testifying on behalf of the National Housing Trust.
Are you the same Roger Colton that authored and caused to be filed the rebuttal testimony marked as Exhibit 1000 in this case?
I am.
Do you have any changes or alterations to your testimony at this time?
I do not.
And if I asked you the same questions today, would your answers be substantially the same?
Yes.
Judge, at this time, I offer Exhibit 1000 for admission into the record, and I tender the witness for cross-examination.
Thank you very much. Are there any objections to the admission of Mr. Colton's rebuttal testimony onto the record as Exhibit 1000? Hearing no objections, that exhibit will be admitted. Okay, so we can proceed to any cross-examination, and we would start with the Office of the Public Counsel. Is there any cross-examination from Public Counsel today?
Yes, Judge. Mr. Colton, good morning.
Good morning.
Mr. Colton, could you briefly break down what are the differences between your recommendations versus Dr. Mark's recommendations? Let me be more specific. What are the differences in your recommendations and testimony as to customer arrearage plans or the company proposals for the company to respond to COVID-19?
Well, my recommendations are, I believe, a little more extensive than the Office of Public Counsels were. I believe, too, that the basis for recommendations differed to a certain degree. I addressed arrearages. I addressed bills for current service. I addressed the reduction of bills, COVID-19 bills that would potentially lead to arrearages and the costs of arrearages, reducing those bills through energy efficiency. I addressed the access of customers to those COVID-19 responses. So I believe that my proposals were somewhat more extensive. I also said that the basis for my recommendations were a little different than the public counsel's, in that as I read the public counsel testimony, the public counsel was interested primarily in reducing arrearages as a mechanism for a long-term reduction in bad debt. And my discussion explained that the purpose of my proposals was not simply to reduce bad debt, but was to reduce the total costs associated with arrearages that were incurred as a result of COVID-19. And those total costs, one component would be bad debt, one component would be working capital that would be reduced through my recommendations. One component would be credit and collection expenses and other aspects beyond bad debt that I talked about in my testimony.
So by extensive, just to take an example, you recommend a full moratorium on disconnections, correct?
I do.
And that's something you disagree with as between public counsel and your position.
I don't remember public counsel's position on a full moratorium.
Thank you. Mr. Colton, looking at your background, you have some extensive education in economics. Are you testifying today as an economist?
Oh, I get asked that question a lot. I don't think one can define what I'm testifying as with any utility regulatory matter. Part of the expertise that I'm bringing is both my academic background in economics, my academic background in law, my practice as an attorney who has litigated utility rate cases. I'm not sure anybody has defined what utility regulatory expertise constitutes as a discipline.
Mr. Colton, you are generally aware of the state of COVID-19 utility responses and the potential for arrearages, correct?
Yes.
And Mr. Colton, given your expertise and your position as a witness now, applying that expertise to your general knowledge of COVID-19, do you expect customer arrearages to generally get worse or better in the coming year?
I would expect utility arrearages to get worse, meaning that I would expect utility arrearages to climb. And there are two aspects to arrearages, both the level of arrears, or I talk about the depth and breadth of affordability, the depth and breadth of arrearages. So the breadth of arrearages will increase, meaning more people will be in arrears. The depth of arrearages will increase in that I would expect that those people who are in arrears will be further in arrears.
Thank you. I have no further questions, Your Honor.
Thank you. Do we have any cross-examination from Renew Missouri?
No, thank you, Judge.
And from Sierra Club?
No, thank you.
Missouri Industrial Energy Consumers?
No questions, thank you.
Okay, and I've heard from Mr. Woodsmall that he does not have any questions. Does staff have any cross-examination?
No questions, Judge.
Any cross-examination from Evergy?
Yes, Judge. This is Rob Hack again.
Thank you.
Good morning, Mr. Colton.
Good morning, Mr. Hack. It's been a number of years.
Yeah, coming on 20, I think. It's kind of scary. I would refer you to pages 23 through 28 of your rebuttal, if you would.
I have it. I'm at page 23.
Okay, and in that section of your testimony, you discuss what you call generally accepted regulatory principles. You use that characterization on page 28, line 6. Do you agree with that?
I do talk, I don't see that on page 28, but I accept that I do talk about generally accepted regulatory principles, yes.
And in particular, how you believe those principles, they should guide cost recovery with respect to deferred COVID costs. Is that correct?
How they should guide utility regulatory commission responses and utility responses to increase COVID-19 costs.
I note that you don't cite any Missouri Commission cases that have adopted those principles. Is that correct?
I don't cite any cases, Missouri or otherwise.
Now, prior to filing your testimony, did you or anyone else for NHT do any research in an effort to find any Missouri Commission cases that adopt or support what you call generally accepted regulatory principles?
I cannot speak on behalf of counsel. I can say that I did not do research to determine Missouri case law for purposes of testimony. Any case law research would be performed for briefing purposes. But but I can't speak for council on what council did or did not do.
Thank you. I would refer you to page 31 of your rebuttal testimony.
I'm at page 31.
And in the middle of that page, Mr. Colton, you present a chart of information you describe as a payment coverage ratio, residential and low income, correct?
I do.
And to be clear, this chart is not based on Evergy data, right?
That's correct.
In fact, on page 30 of your rebuttal testimony, you say that the chart uses consumers' energy information, and I quote, given the lack of Evergy data. Did I characterize your testimony accurately?
Yes, at page 30, line 22, given the lack of Evergy data, I first illustrate the problem using data from Consumers Energy Michigan.
Mr. Colton, did you or anyone else on behalf of NHT send a data request, any data request to Evergy seeking information in this proceeding?
To my knowledge, NHT, I wouldn't send data requests, of course. To my knowledge, NHT did not send a data request given the time constraints involved.
Before filing your testimony, did you ask Evergy or anybody else for NHT ask Evergy whether billing system changes would be needed to effectively administering your proposed arrearage management program?
No.
Did you ask how much any necessary billing system changes would cost?
No.
Did you ask how long it would take for the company to make any necessary billing system changes?
No.
Did you ask, prior to filing your testimony, whether employee training would be needed for Evergy to effectively administer your proposed arrearage management program?
No.
Did you ask how much any necessary employee training would cost?
No.
Did you ask how long it would take Evergy to undertake any necessary employee training?
No.
Prior to filing your testimony, Mr. Colton, did you ask whether customer education and customer communication materials would be needed for Evergy to effectively administer your proposed arrearage management program?
And I didn't clearly hear that. Customer education and customer
communication materials?
Did I ask the company whether they would need to prepare that? No.
Did you ask how much any needed customer communication and education materials would cost Evergy?
No.
Did you ask how much time it would take for Evergy to prepare customer education and customer communication materials regarding your proposed arrearage management program?
No.
Is there any place in your testimony where you set forth an estimate or an exact figure of the number of customers for Evergy Missouri Metro and Evergy Missouri West who are at or below 200% of the federal poverty level?
No.
And is there any place in your testimony that sets forth what would be a subset of those customers who have arrearages greater than $300?
No.
Thank you, sir. That is all I have.
Thank you. At this point, we could take questions from the commission. I don't have indications that we have any of those, but I know our commissioners will speak up if we do. I don't know, Mr. Colton, if you're able to speak to any of the statements that are made in the National Housing Trust Statement of Position. Is that something that you can address or not?
I did not prepare that or participate in its preparation, but if there are specific statements, I can talk about them relative to my testimony.
Well, we'll see if you're able to answer this question. Apparently, one of the responses as to issue 2 in the Statement of Position indicates that tracking of COVID-related revenues and expenses should take into account the normal variation in expenses that Evergy normally experiences. Are you able to tell us anything about what that statement of position means in regard to normal variation?
I know that I have testified in other states about how utility revenue and expenses are not consistent from year to year. So, for example, in a Rhode Island proceeding, I was testifying on behalf of what in essence is the staff, the Department of Public Utilities, and examined the FERC Form 1 data, and you can look at FERC Form 1 data, and expenses go up and down from year to year. So there is simply a normal distribution. I don't mean that in a statistical sense, but there is a normal fluctuation or an expected, normal may not be the best word, an expected fluctuation from year to year in expenses.
And would that be determined by looking at a range of years?
That's what I would do, yes.
Okay. I don't see that we have any additional pending questions from the bench for Mr. Colton, so we can move on to recross. If there is any, does the Office of Public Counsel have any questions for Mr. Colton?
None, thank you.
And Renew Missouri?
No, thank you, Judge.
Thank you. Sierra Club?
No, Judge.
Missouri Industrial Energy Consumers?
No questions, thank you.
And Midwest Energy Consumers Group?
No questions, thank you.
Staff?
No questions, Judge.
Any recross from Evergy?
No, Judge.
Thank you. Any redirect from National Housing Trust?
Just briefly, Judge. Mr. Colton, counsel for Evergy during cross was just asking you about whether you or NHT asked any questions about the costs of billing system changes or training or time to implement the arrearage management program and other recommendations you made in your testimony. And you answered no, is that correct?
That's correct. That's correct. I answered no.
You're right. If you had answers to any of these questions, would you imagine it would change any of your recommendations in your testimony in any way, given the security of the crisis?
No.
Thank you. No further questions.
Thank you. That will conclude your testimony today, Mr. Colton.
Thank you, Your Honor.
Okay, so I think that puts us into the position to wrap things up this morning. I think what we'll be doing is kind of flashing back to the opening of the proceeding when the commission could ask questions of counsel. So I do have a question to ask the parties, and I will give any party that would like to respond to that today, I would encourage you to address it today, but also to address it in your briefing. So a question that has occurred to the commission is what the party positions are in regard to the proposed stipulation and the AAO. If the provisions in paragraph 16, 17, and 18, either the commission were to determine that it didn't have authority to order those provisions in relation to an AAO, or if the commission determined it would be inappropriate to use its discretion to do so. Would that change the party's position in support of the AAO that is proposed by that stipulation? And if you need me to clarify what I mean by that, I can understand and I can try again.
Judge, your paragraph numbers were 8, 16, 17, and 18?
It was 16, 17, and 18.
Thank you.
Judge, I'm happy to take a stab at answering, although I think my answer may be dependent on a more specific understanding of what you mean. But I would tell you that with respect to paragraph 16, the first part of that paragraph until the second to the last sentence simply recites historical information and the existence of the cold weather rule, which I think does not implicate the commission's authority in any respect whatsoever. The last two sentences deal with the company's commitment to an agreement to evaluate the advisability of extending offers of 12-month payment plans beyond the end of the year for small business customers and beyond March 31st for residential customers in consultation with staff, OPC, and NHT. And then the last sentence does the same thing with respect to additional customer programs.
So let's hold on one second. Let's stop right there.
Okay.
And I apologize for interrupting you. I'm going to open this up so that I can look at it while we talk about it. It's not as easy to find as it should be. Okay, so the first, I'm sorry.
I just wanted to verify, was that Mr. Hack speaking?
Yes. And I think, Mr. Hack, you just responded, but it looked like you were muted.
The answer was yes. Ms. Court Reporter, thank you. It was Mr. Hack.
Okay, and I apologize for stopping you while you were answering the question. I wanted to be able to look at the specific paragraphs. So the first part of your answer was saying that paragraph 16 simply recites what already happened. And then there are a couple sentences to the end there that do seem to include some kind of obligation on the part of the company. So would you characterize the agreement to evaluate the advisability of offering additional customer assistance programs as part of the conditions of this AAO under the stipulation?
It is an agreement that is expressly made by the company as a part of this non-unanimous stipulation and agreement. As Mr. Casely testified yesterday, I believe, these are this reevaluation or continued evaluation for both items is something we would be doing regardless. And I think as Dr. Mark recognized in his testimony today, we have been meeting, the company Evergy has been meeting with staff and OPC on a regular basis to discuss customer payment practices, COVID impacts. I do not know personally whether National Housing Trust has been a part of those discussions. These last two sentences of this paragraph 16 would expressly obligate us to invite NHT to those discussions. Obviously, they're not a signatory. They can choose to attend or not. But these are, I do not see these last two sentences as implicating commission authority at all. Now, if we were to propose something, or if the commission was to simply, on its own accord, order us to do something with some conditions regarding cost recovery, then there may be implications regarding commission authority. Is that fair? Does that make sense?
Well, I think we need to go back to the first question that's being asked here is not the question that I posed at the beginning of the hearing, which is really a question about the extent of the commission's authority. This is a question about the parties' positions at this time. So if the commission determines either that it doesn't have authority to direct these kinds of activities that are identified in 16, 17, and 18 of the stipulation and agreement, or it decides that it's inappropriate and therefore is not going to do so, what are the parties' positions about going forward with the rest of the agreement? And I doubt very much that Evergy's position would be really hard for anyone to understand on that, but perhaps the other parties might have a more complicated position if these provisions are not included in an AAO that the commission would order, right?
I think you had just alluded to this, Judge. I mean, we support all of the paragraphs, and we would be willing to move forward without these as a part of the order.
Your Honor, this is Dave Woodsmith for MECG. You'll notice in paragraph 16, it talks towards the bottom that these payment plans affect residential and small commercial. As you note from my application intervene, my interests are on behalf of large commercial and industrial customers. So this paragraph really does not affect my interest in the case. So MECG would be willing to go forward whether this provision is in or out. That said, it is part of an overall negotiated package, and we'd urge the commission to leave it in.
So are paragraphs 17 and 18 something that your client or clients believe would have to be part of an AAO order that your clients are asking the commission to issue in this case?
As Mr. Hack was talking about paragraph 17, I talked about paragraph 16. That doesn't really implicate my interest. Paragraph 17 is more a reflection of what has happened in the past, that the company has made this $2.2 million of contributions. It is important to us that be booked below the line, and the company has made that affirmative agreement. Paragraph 18 does not concerns practices of full credit reporting. I believe that's more of a residential issue, so that doesn't implicate my interest either.
So really the only portion of these three paragraphs that is significant in your mind for your interests would be that the contributions or relief provided by the company would be recorded below the line, essentially.
Referring specifically to the 2.2 million it's already made. As far as programs above and beyond that, those are addressed elsewhere in the stipulation, but the 2.2 million, you are correct.
Okay, and I think that, the reference to these paragraphs probably should be understood as a reference to any conditions that the commission would attach to an AAO, such as have been advocated by some of the parties to provide some relief to customers. So, that's really what these paragraphs represent in the agreement. So I don't know if there are some additional references to that are littered throughout the stipulation that should be understood as being part of it. But the larger question is, if the commission decides it either doesn't have authority to attach this type of condition or declines to use its discretion to do so, does that change the parties' positions in asking the commission to issue the AAO that Evergy has requested? And so I think you've answered that now for your clients, Mr. Woodsmall. But if you wanted to make additional comments, I'm sure the commission would be happy to hear them.
Yeah, that was all I had. Thank you.
And Judge, I can attempt to address your question from staff's perspective. Staff supports the terms of the non-unanimous stipulation agreement in total. And I still agree with, I believe it was Mr. Woodsmall who said in his opening statement that between the filed testimony in the case as well as the live testimony that's been given, there's enough here for the commission to make findings in fact and conclusions of law for every single one of these terms. And as you previously noted, all parties will be addressing authority in brief. So we will also be doing that. But I guess to get a little more specific, our witness, Ms. Dietrich, was asked about, I think in particular, paragraphs 16 and 18. And her response was, while we did not address those in testimony, we found them to be reasonable. That said, paragraphs 16, 17, and 18 are not staff proposals found anywhere in our testimony, our pre-filed testimony, or our live testimony here. So, I guess to mirror Evergy's response on, would staff still support a deferral for Evergy for COVID-related costs? Yes, so long as those, didn't include lost revenues, as long as the other terms of the stipulation agreement were present. If paragraph 16, 17, and 18 were no longer there. But again, reiterate, we support in total all of the paragraphs in the document.
Thank you very much. And I believe on my list of opening statements, it would have been Sierra Club that would have spoken next. So would Counsel for Sierra Club like to say anything at this point about the question that's been posed?
Well, Judge, we filed testimony only on the lost revenue issue. We are broadly supportive of the protections advocated for by NHT and OPC. I do not think, however, that our support would change if those paragraphs were deleted. Let me say that it's provisional because since I'm not directly employed by the Sierra Club, I find that sometimes it's best to let their staff counsel speak rather than me.
Okay, and so there will be some briefing, and to the extent that your client needs to clarify their position, they're going to have a chance to do that.
I will certainly make it known to them.
Missouri Industrial Energy Consumers, Ms. Plesha, did you want to address today that question from the commission?
Yes, I would like to make a few comments. I understand that the commission has full authority to make any decision that it chooses to based on the evidence in this case, and that this stipulation and agreement under the commission's rules is merely a position of the parties to be considered. I think that when it comes to a stipulation, as you know, so many trade-offs are made by the parties, and there are so many things that go into the decisions about parties to take these positions and include the various provisions. And there is truly an interdependency in the sense that the parties are making trade-offs with each other to arrive at a conclusion that we're all going to mutually support something. And there are trade-offs made by parties who may have sought these consumer protections and maybe didn't oppose this, for example, or would have done something differently if they'd known these provisions were taken out. That being said, we recognize that the commission is going to decide based on the evidence what it finds to be reasonable. So I want to affirm that the MIEC supports this stipulation as it's written. We understand the commission may come up with a different decision. We hope the commission will preserve as much as possible of the stipulation. My clients are just large industrial, not large commercial, but large industrial consumers, and we are relatively unaffected by residential and small business consumer protection provisions, but we also support them and think they're very valuable. And I would just add that with respect to 16, 17, and 18, these paragraphs have always struck me more as a recitation of things that the company was doing already. And each of them has an agreement, for example, for the evaluation of programs. The below the line aspect of it is certainly, an important aspect, but a lot of the things in these paragraphs are just recitations of what the company's doing. And I certainly am not prepared to say at all that the MIEC wouldn't support the stipulation without these items, but I hope the commission will give consideration to the fact that trade-offs are made in order to get to this document. And that's all I have.
Thank you very much. Would the Office of Public Counsel like to make any comments on these issues at this time?
Sure. Thank you, Judge. While understanding that Public Counsel opposes the stipulation agreement as currently drafted, our opposition was rooted mostly in the presence of the language contained in paragraph 8 and the absence of language similar to what was agreed to in American Water and Spire, Missouri's COVID-19 related AAO. For the paragraphs you're asking about, just off the cuff, 16 and 17, OPC sees as largely lacking functionality. 18 would be the only paragraph that has any sense of operative language in that it's something that can be pointed to it can be something that can be pointed to in the event that Evergy wishes to change its mind on the practice of waiving late payment fees or credit reporting. At this time, I think I'd like to make note to the commission that traditionally with the practice of providing stipulations to the commission independently adopts the stipulation. If the commission has any reason to take offense or not like a particular provision in the stipulation, the commission need not be subtle on that point, and if the commission has any trepidation about its authority to order conditions, the commission can most certainly ask parties to go back to the drawing board.
Thank you, Mr. Hall. Would National Housing Trust like to make any comments at this point?
Thank you, Judge. I'd like to reiterate some of the comments of OPC's counsel. NHT sees paragraph 16 as essentially without function. It commits the company to agreeing to evaluate the advisability of extending its offer of a 12-month payment plan. Of course, we'd be hoping that the commission would insist on a similar condition here in this case. In fact, a stronger condition of a full arrearage management program to limit customer arrearages. So we don't see that paragraph as committing the company to much at all. And I think the same can be said for 17 and 18. We would just urge the commission to, we have no objection to the costs that are slated to be recovered as part of the AAO proposal in this case. We just ask that the commission insist on several conditions given the severity of the crisis that we find ourselves in. And we'll flesh that out further in briefing.
Okay, thank you. And finally, does Renew Missouri have any comments to make on that question from the commission?
Sure, Judge. So I guess to the broader question of commission authority, I mentioned generally in my opening statement that I believe the commission has broad authority to attach conditions, and I'll address that in briefing. And to the specific questions about our position, change in position, if those were added or deleted from the stipulation, I don't think it would change our position. Renew Missouri did not sign, but did not object to the stipulation.
Okay, so the question that was posed to the parties at the beginning of the proceeding was to address in briefing the commission's authority to attach conditions in an AAO order. And I think there should probably be some nuance there because there are all sorts of different kinds of conditions that the commission might attach in different orders. So I think one of the questions that's posed there is the commission's authority to attach conditions that essentially create new programs or require certain treatment of customer arrearages or pick up some of the recommendations that were made by some of the parties. And so that's where the main question of authority goes. There may be other kinds of conditions that would appear in a commission order. I'll take, for example, reporting requirements. So I think the question would be, while maybe it's a different situation to question the commission's authority to require certain kinds of relief for some customers, as opposed to whether the commission has authority to issue an AAO and also tell the company, we're issuing this AAO and you're going to report this information to us every 6 months. So I hope that the parties will address the commission's authority and perhaps also different kinds of conditions, because that seems like an obvious issue there to me. So I'm going to give you one more opportunity, I guess, on substantive matters, if there's anything you wanted to say to the commission at this point, and then we can talk about the briefing schedule and any other closing matters that might exist. Does anybody need to clarify anything that was said before or want another opportunity to address the commission on anything?
Evergy does not. We're prepared to brief.
MECG will brief as well.
Okay. It doesn't look to me like we're going to have any late filed exhibits. I think everything that was offered has actually been provided to me, which means it's in the possession of the commission, and I can actually hand it off to staff to mark and file an EFIS, and then all the parties would have a chance to verify that what is labeled and filed in EFIS matches what was offered. So I would anticipate that would be the next step, and then I would put an order out that would specify a time period to let us know if any mistakes were made. Does that seem like a reasonable process?
Judge, this is Rob Hack, and I think it does, but there was maybe a little bit of lack of clarity in my mind on what you want us to do with exhibits that were corrected on the stand, but not, those corrections weren't in the numbered exhibits that were provided to the parties.
Thank you for bringing that up. I think that because of some other cases I had reviewed, I was under the impression that corrected testimony or corrected exhibits actually did ultimately get corrected in the true sense. So I think I had assumed that that's how things would be done. And to be honest, I would prefer that it was done that way, because otherwise it's necessary to make a note that this was corrected, and then make sure that in any order you reflect that accurately if those changes happen to actually make a difference. It seems like often they don't make much of a difference. So I mean, I think that was just part of my not being familiar with exactly how things are typically corrected before the commission. And also, I would prefer to just actually have things that are corrected filed in their corrected form. But I don't want to invent a new procedure that nobody's familiar with. So I'm willing to listen to the parties if they say, this works just fine like this, don't worry about it. So.
Yeah, I think given your preference and the fact that I think the only correction that we offered was in the non-unanimous stipulation and agreement, which is, or could be, a meaningful document, and it's really only the change of one digit. I think we would go ahead and commit to file a corrected Exhibit 1, so that the record is clear.
Does any party have any objection to that?
And Judge, staff has no objection. I would just ask the same question of, we had a correction to Ms. Boland's testimony, Staff Exhibit 100, to both her public and confidential versions. It was just a couple of words, but like Mr. Hack said, I'm okay with just filing that as well. Because I know you offered into the record the corrected versions anyway, so.
So because you're all being so helpful, let's do plan on having corrected exhibits filed. And so what I will do is put together an order that will specify when they should be filed. And also that will probably coincide with when the rest of the exhibits will be appearing in EFIS and have been marked. And that will let everybody know by what date they need to make sure that everything was correct. So instead of doing our in-person routine, which as I understand it is people hand exhibits to the court reporter, she makes sure they're all marked, and then she hands them back over to the commission and we get them filed. Because I already have them in my possession, I'll take care of making sure they get filed. And I'm not going to set any timeframes on that right now because I would just rather do it in writing. So does anybody have any other questions about exhibits?
Judge, I just wanted to confirm that my notes were right, that all the Evergy exhibits that we pre-filed have been offered and accepted.
Yeah, I can go back and look at the exhibit list that I have for you. I do have everything marked as admitted based on the list of 9 exhibits from Evergy. And
that's my notes too. Thank you.
Right. And then as was discussed before, there has been a clarification or correction as to a single date in the stipulation.
Yes.
And Mr. Hack indicated that he would submit a correction, and so that will be submitted under an order that will come out soon.
Thank you.
Okay. And I can look at all the exhibit lists with each party if you would like, but really they weren't very extensive, so I think it's pretty clear. The only other minor complication we had was the shared witness with the energy parties. And so that's going to be marked as a Midwest Energy Consumers and Missouri Industrial Consumers exhibit, number 300, I believe. So I'll make sure that that happens as well. And of course, there'll be a time period to fix that if it isn't done exactly right. So any other comments or concerns on exhibits?
Judge, please don't take this as a complaint. Do you wish public counsel to still file corrected testimonies of Dr. Mark's testimony given the errata sheet?
No, I think that handles that just fine. It's in writing, and I don't have to remember anything, and I can go back and look at it anytime I want. So that's perfect.
I truly didn't mean that to be a complaint. We'll do it if you want. I just wanted to.
No, that's fine. All right. Any other comments on exhibits? Okay, so I checked, and our transcript date normally would have been on Thanksgiving, but our court reporter service has graciously agreed that they're actually going to have these ready for us on November 25th. So that's when transcripts will be available. And initial briefs are December 4th and reply briefs December 14th. I presume those dates are still acceptable to everybody. Okay, so I'm sorry. Are there any other matters to discuss before we end our hearing?
Judge, I just wanted to thank the parties, the commission, and particularly the regulatory law judge and the court reporter and our IT guy for all the extra work that this brought to the table. It certainly was an interesting proceeding, and you did a great job. But thank you for all cooperating to make this a safe proceeding.
Thank you very much, Mr. Fisher. I think we've covered everything. Thank you so much, everyone, for being here and keeping your lines muted. So I hope you all have a wonderful day. This proceeding is now adjourned. Thank you. We're off the record.
Thank you, Judge.
Thank you very much.